Okay, let's take a look at the evaluation part of the criminal courts, and there are two quick things to say. The first is that we're going to talk about lay people. We're going to evaluate the work of lay people, and I'm going to do that in two videos. The first of which is this one, is we're going to look at magistrates, and the second video will look at the jury system. And just be aware that where the exams board asks you a question that asks you to evaluate lay people generally, they will normally be talking about both magistrates and juries. If they just want you to discuss magistrates, they will say evaluate the advantages and disadvantages of magistrates or of juries. So that's the first thing. The second thing is just to remember that where we're going to talk about some of these issues, and I've only chosen a few, there are many advantages and disadvantages. It is true that for everyone there is a counter argument. So we may say that it's less expensive for a magistrate system, but at the same time you could argue that cost should be irrelevant in terms of maintaining a completely fair and impartial judicial system. So each of these areas has both advantages and disadvantages, I guess, is what I'm trying to say. So the first of the advantages is cost, and without doubt it is cheaper. So it is a cheaper system. Oh, I've lost my pen. It is a cheaper system to have a magistrates court system. And the reason for that is if we were to flood the court system with the judges that we would require, and we'll look at that in advantage number 3, each one earning, let's say on average, around about £90,000 each, the cost to the taxpayer would be probably about in the region of £100 million. So the magistrates court saves us around about £100 million per year to run. That takes into account, of course, that we won't need a legal advisor. We won't need to pay a legal advisor, but we would still need some administrative support. So even with all that taken into account, you can see the fact that the magistrates court system saves a great deal of money per year to the taxpayer. The second advantage and the second area is the fact that magistrates have a lot of local knowledge. If you can imagine a witness giving evidence and talking around about a particular place or location, the magistrate would know exactly where that was. They would know what the lighting was. They would know what the visibility was. They would know the area well. And that's because magistrates are taken. Magistrates tend to sit at the bench in the area in which they live. So local knowledge is key. That is further developed in some key statutes. So, for instance, the Drugs Act 2005 allows for a certain amount of what's called trigger offence tests, which means that the police can stop somebody in committing one crime and carry out a search for drugs as a result of that stop. And that's location specific. And the magistrates are best placed to decide whether or not the police have acted under the Drugs Act 2005 far better than a jury or a judge might. And from that, we bring us to a bit of case law. We can illustrate that with a wee bit of case law. And here we see the case law, which is Paul versus the DPP. And that is 1989. And in that, the court had to decide whether or not, or the impact that curb crawling, street walking by prostitutes had on a local area. And the magistrates were very, very clear that they felt that the impact of prostitution and curb crawling on the particular area concerned had a huge impact because they knew the local area. When the defendant appealed that case, Lord Wolfe in the Court of Appeal said that this was precisely the sorts of cases that magistrates were best suited to. So the third area that I want to talk to you about is the availability of judges. And to change the system to an entirely judge-based system would require us around about 1,000 new judges. And that means that we would have to change the way completely that judges were selected because our current pool is not big enough. Thirdly, rather something a strange title, they're better placed to deal with issues. Most cases are well, there are mainly guilty pleas, I think is what I'm trying to say, in the magistrates court. And where there aren't, most are dealing with conflicting evidence. So most cases deal in the magistrates court with conflicting evidence. And the magistracy are best placed, and they can deal with these issues easily because they're not about conflicting law. The magistrates can decide, they can look at, they can hear, they can listen to witness testimony, and they are best placed to deal with that quickly and in the best possible manner. Similarly, so they provide a good cross section of society, particularly when one looks at the issues of race and gender. So they will know the nuances of that area on issues of race and gender, as well as being able to very quickly decide whether or not a defendant has a case to answer or not. And lastly, there's an issue of public confidence. The public generally tend to be very confident about its magistracy. They see it as a form of active citizenship, and we looked at that on the previous couple of videos when we talked about civic duty. And even so, the public are more confident in judges and they're more confident in jury trial. Recent surveys have suggested that the public don't want to see any changes in the magistracy. They don't want to see that changing or having less of an impact. So those key 5 areas, it's cheaper, it's less costly. There is local knowledge, and the impact of local knowledge is important. It means we would need far more judges to change the system. Magistrates are better placed to deal with issues than perhaps judges are in certain cases. And generally, there is a public confidence that means that the public would not want to see the magistrate system change overly. Tempered and balanced against that, of course, are the disadvantages of this type of system. And the first is, which sort of counters the sort of thing I was saying about representative in terms of gender and age, and sex, gender and race, is the fact that, to be fair, the magistracy is unrepresentative society. It is predominantly white. It is mainly middle class. It is generally professional, so most of the people on there come from professional occupations. It is full of wealthy individuals, and most of whom are middle-aged. Now, when you think about that, there are only 5% of the magistracy that are under 40 years old. Okay. And most defendants in that system are under 25. That's not necessarily representative. So we move away from this idea about people being understood by the people that are trying them. And the next thing to look at, although I will go back and say, in fairness, there is a level of racial representation. The numbers tend to suggest that we are more racially representative on our magistrative representation, more racially representative on our magistrate system. The next disadvantage is that there is some inconsistency. Even in neighbouring benches, there is some great inconsistency. And the courts tend to be inconsistent in 2 areas. The first is on sentence, and the second is issues on bail. And just to give you some idea how unrepresentative, inconsistent that they are, if you look at the regional custody, so people that were put in prison for ABH, okay, in 2005, in Bristol, that figure was 26%. Yet in Devon, not very far away, that figure was only 14%. So you can see immediately that different magistrates in different areas are inclined to deal with people in a different way. So if you're an individual and you were up in front of the bench in Bristol, you would be far more likely to end up going to prison than you would if you were in Devon. And that can't be fair, because you should receive a trial that's fair in terms of its sentence, no matter where you are. The next is that judges tend to be slightly case-hardened and biased. What does that mean? Well, it means that, let's just imagine that if you're a magistrate, you might be hearing 30 TV evasion cases per morning. So let's just say you hear 30 TV cases per morning. By the time that the 29th comes along, do you think that you are going to listen fairly? And the answer is probably going to be no. The other thing is that they will see in those 30 perhaps the same policeman 4 or 5 times. And certainly over the course of a year, they will become very familiar with the same police officers or the same specialists that come and give them evidence. And very often what does that mean is that the magistracy tends to believe the police. And there's a good example of that, and I have to write this out, I should have written this out further actually, a very key case, and that's Bingham Justices ex parte Jowett, and that's 1974. And that's a case, a motoring dispute between, it was a motoring dispute, and the only 2 witnesses, one was a driver and one was a police officer, and their witnesses were contradictory. And the magistrate in that case said that they were going to believe the police because their general rule was that they always believed the police. And of course what happened was the motorist appealed, that was appealed, and the judge, of course, the judges overturned the original decision on the basis of the fact that it was biased. Because if there are only 2 witnesses and they both give contradictory evidence, then the difficulty is going to be that you can't believe either. And if you are going to solely believe one of them, then I would suggest that's going to be a more biased system. It's also the key that less than 1 in 100 magistrates' cases are successfully appealed. So less than 1 in 100. That's not many at all. If you look at the figures as well, and we won't go into that because of the length of the video, but if you look at the figures about cases that are tried, then you can see a very clear bias against the defendant in terms of magistrates' courts. And finally, there's a reliance by the magistrates as a disadvantage on the legal advisor. As we all know, the legal advisor is a solicitor, a qualified solicitor, who advises barristers on points of law. So they advise on points of law. The problem is, very often, and if you visit a magistrate's court, you'll see this, the magistrates are always leaning forward, talking to the advisor. They're getting up and leaving the court, and the advisor goes with them to advise them in their chambers behind the scenes. And that can seem to be very conspiratorial by the defendant. So even if they are not necessarily biased, there is an over-reliance on the legal advisor, and it can appear that the legal advisor's role is not one of unbiased nature. It looks as if they are consorting with the magistrates. So that can be a disadvantage as well. So the 4 key disadvantages that we're going to talk about, just as a recap. The first is that generally magistrates tend to be unrepresentative of society. Second, that magistrates tend to be inconsistent. Thirdly, that inconsistency in a great deal comes from case hardening and some bias. And finally, there's an over-reliance on the legal advisor. I'd suggest you learn all 5 of those, and they will form the basis for an evaluation question on the magistracy as lay people.